Your grandmother passes away. The will is read out loud at the kitchen table, and it says one thing very clearly. Everything gets split equally among her children. Simple, fair, done. Except there's a problem nobody mentioned at that table. Years earlier, your grandmother had added your mother to her checking account, and when she died, that account, every single dollar in it, never touched the will at all. It just became your mother's, while her siblings split whatever was left of the life insurance and called it even. Here's the thing. If your stomach just tightened a little reading that, good. That means you're paying attention, because this exact situation plays out in families across this country constantly. And almost nobody understands the legal mechanism behind it until it's already too late to do anything about it. Today, we're pulling this apart completely. What actually happens legally when a parent adds a child to a bank account? Why that single decision can quietly override an entire will? The surprising legal landmines that decision can create for everyone involved, and what you should actually do if you're standing in the middle of exactly this kind of family situation right now. Hello, I'm Anne. Welcome to my channel. This video is for educational purposes only and does not constitute legal, tax, or financial advice. Let's start with the question almost every family asks first, because it's the wrong question, even though it feels like the obvious one. Was this fair? Look, fairness is a real thing. Ethics matter. Nobody's pretending they don't. But here's an uncomfortable truth that catches almost every family off guard. When it comes to actually dividing up what's left after someone passes away, fairness and ethics aren't what determines who gets the money. The law is. Not the law is important too. The law is the only thing that legally determines the outcome here. Full stop. Everyone in a family situation like this absolutely should try to act with integrity toward each other. That matters enormously for keeping relationships intact. But legally, the rule is the rule, whether anyone likes how it lands or not. So here's the reveal that genuinely surprises most people the first time they hear it. If your mother was a co-owner on that joint bank account, not a co-signer, a co-owner, then she is, legally, completely entitled to keep every dollar in that account. That's not a loophole. That's not a technicality someone's exploiting. That is exactly how a properly structured joint account is designed to work. The money in that account was never part of the estate to begin with, which means it was never subject to the will's instructions in the first place. The will said split everything equally, but a joint account with a surviving co-owner isn't everything. It already belongs, in full, to whoever's name is still attached to it when the other person passes away. Now here's where I need you to pay very close attention, because this single word, co-owner versus co-signer, is the entire hinge this whole story swings on, and almost nobody outside of estate law actually understands the difference. A co-signer is someone who's been given the authority to write checks and manage transactions on someone else's behalf. Think of it like having the keys to someone's car so you can drive it when they need an errand run. You can operate it, but it's still their car. A co-owner, on the other hand, is treated as having an actual ownership stake in that account, the same way two names on a house deed both legally own that house. So when an elderly parent gets added to a joint account as a co-owner and not just given check-writing authority, they're not just helping manage the money anymore. They're legally an owner of it. And when the original account holder dies, ownership simply transfers automatically to whoever else is still on that account, completely outside of the will, completely outside of probate, completely outside of whatever that will document says about splitting things equally. This is the part that should genuinely stop you in your tracks if you're someone who has an aging parent right now. The difference between those two words, co-signer and co-owner, can be the difference between an entire bank account staying inside an estate to be divided among siblings or vanishing from that estate entirely the moment a parent passes. And And here's the kicker. A lot of elderly parents who add a child to their account have no idea which one they actually signed up for. They think they're just making it easier for their kid to help pay bills if something happens to them. They don't realize they may have just handed over full legal ownership of their life savings. So now you're probably wondering, is there any way to challenge this if it genuinely seems wrong? And yes, there is, but it's a narrower path than most people expect. If there's real reason to believe the parent was under undue influence, was coerced, or lacked the mental capacity to truly understand what they were signing when they added that child to the account, that changes the entire legal picture. But here's the catch that trips up almost every family who tries to go down this road. The burden of proof falls entirely on whoever's making that claim. And we're not talking about a gut feeling or a suspicious vibe at Thanksgiving dinner. We're talking about extensive documentation, medical records, financial paper trails, real evidence that something improper happened, not just a sibling who's upset about the outcome. And here's a detail that catches people completely off guard when they finally decide to pursue this legally. Claims of financial exploitation are generally bound by a civil statute of limitations, meaning you typically have somewhere between 3 and 6 years, depending on your state, to actually file a claim. After that window closes, it doesn't matter how legitimate your suspicion is. The legal door is shut. So if something about how an account was set up feels genuinely wrong to you, the clock is already running, whether you've noticed it or not. And waiting 5 years to process your feelings before taking action could cost you the legal right to act at all. Before we go further, let's talk about why parents even set things up this way in the first place, because understanding the why actually makes the whole situation feel less like a betrayal and more like an honest mistake born out of love and practicality. Most elderly parents aren't trying to secretly favor one child over the others when they add someone to their bank account. Usually, it's purely logistical. They're thinking about what happens if they end up in the hospital and someone needs to pay the electric bill, or what happens if they pass away suddenly and someone needs immediate access to cash for funeral costs before the slow machinery of probate even gets started. Probate can take months, sometimes over a year, and bills don't wait for the legal system to catch up. So a parent adds the child who lives closest, or the child who's most organized with paperwork, purely as a practical safety valve, never imagining that single decision might quietly reroute their entire life savings away from a will that says something completely different. And here's the myth I really want to dismantle, because I guarantee some of you watching this are thinking it right now. Isn't this basically stealing? No, and this is exactly the distinction that trips people up. Stealing implies someone took something they had no legal claim to, but a properly structured joint account with survivorship rights isn't theft. It's a contract agreed to by the original account holder while they were alive that determines what happens to that specific asset the moment they're gone. It might feel like theft to the siblings who didn't know about it. It might even feel unfair because, let's be honest, it often is unfair in the everyday sense of that word. But unfair and illegal are not the same category, and confusing them is exactly how families end up in expensive, relationship-destroying legal fights over money that was, legally speaking, never up for grabs to begin with. Let's bring this down to earth with a real story, because abstract legal rules are one thing, but watching how this actually plays out between real siblings hits differently. One woman shared her own experience with exactly this kind of situation. She'd been added to her father's bank accounts specifically to help manage his bills near the end of his life. Funeral costs, property taxes, that kind of thing. And she also served as his executor. After the house sold and every outstanding bill, including final payments to Social Security and Veterans Affairs, were settled, she made a deliberate choice. She split what remained equally with her siblings. She never put a cent of her own money into those accounts, and she understood the spirit of her father's will to mean all 3 siblings were meant to share everything evenly. By her own account, she wasn't legally required to split that money at all. She simply never felt entitled to keep funds that weren't intended to be hers alone. That's a genuinely beautiful outcome. But here's the uncomfortable truth sitting right next to that story. Not everyone makes that same choice, and legally, nobody can force them to. The entire reason that situation could have gone differently rests on one structural decision made years earlier, being added as a co-owner instead of a co-signer. Same intention from the parent in both scenarios. Help me manage things and make sure my kids are taken care of. But one structural choice in the paperwork determines whether that intention is legally enforceable or completely optional. Now let's talk about something most families never even consider because it flips this entire conversation around. Being added to a joint account doesn't just create risk for the siblings who get left out. It can create serious, sometimes shocking risk for the person who gets added to. An estate attorney based in North Dallas lays out a cautionary scenario that I think every family needs to hear because it shows just how many ways this can quietly go wrong for everyone involved, not just the people excluded from the money. Picture an elderly parent adding someone, let's call him Jim, whether he's a son or a close family friend, onto their bank account as a joint owner with survivorship rights. The moment that account is set up that way, Jim has effectively received a gift. If the balance is small, that's probably not a big deal. But if there's a substantial sum sitting in that account, the family may need to deal with gift tax filing requirements they never saw coming, simply because of how that account was structured on paper. And here's where it gets genuinely messy. If there's ever an accounting error, an overdraft, a bounced payment, both names on that account can be on the hook for it, regardless of whose money actually caused the problem. Now imagine Jim goes through a divorce. Because he's a legal owner of that account, he may be required to disclose it as part of the divorce proceedings, which means funds his parent considered untouchable could suddenly become part of a contentious legal negotiation with someone Jim wishes he'd never married in the first place. You can fight to protect those funds from creditors, from an ex-spouse, even from the IRS, but fighting costs time, costs money, and costs peace of mind that nobody in this story signed up to spend. And then there's the twist that I think is the most unsettling part of this entire cautionary tale. That money might not even be available for the very thing the parent assumed it was earmarked for. If the parent passes away with $200,000 sitting in that joint account, but their funeral only costs $10,000, Jim, as the legal owner, is under no obligation whatsoever to use any of that remaining money to actually pay for the funeral, if he doesn't want to. Legally, once the original owner passes, that money belongs entirely to Jim. The parent's unspoken assumption, of course my child will use this the way I intended, has no legal weight at all once it's structured this way. Intent and legal ownership are not the same thing, and conflating them is exactly how so many families end up blindsided. So let's pull all of this together into something you can actually act on, because I don't want you walking away from this video just feeling anxious about your own family's accounts without a clear next step. First, if you are the parent in this scenario, or you're helping a parent set up their finances, get crystal clear on whether you're creating a co-signer arrangement or a co-owner arrangement. And don't assume your bank explained the difference clearly when you signed the paperwork, because plenty of people walk out of that meeting with absolutely no idea which one they just agreed to. If your actual intention is for the money to be split among all your children after you're gone, a joint account with survivorship rights for just one child is very likely the wrong tool for that job. A payable on death designation or clear specific instructions inside a properly drafted will or trust may serve your actual intentions far better than an informal joint account ever will. Second, if you're the adult child being added to a parent's account purely for convenience, to help pay bills, to step in during an emergency, push for a co-signer or limited power of attorney arrangement instead of full co-ownership wherever possible. It accomplishes the practical goal of helping your parent manage their finances without quietly turning you into the sole legal owner of money that was never meant to be only yours. Third, Document everything, starting today, not after a crisis hits. If you're managing a parent's finances, keep a clear paper trail of where money came from and where it went. If a sibling ever questions what happened with an account after a parent passes, that documentation is the difference between a 5-minute conversation that resolves everything and a multi-year legal battle that drains the very money everyone's fighting over. Fourth, if you genuinely suspect undue influence or impaired capacity was involved in how an account was set up, don't sit on that suspicion. Remember, that statute of limitations, typically 3 to 6 years depending on your state, is already running whether you've acted on it or not. Consult an estate or elder law attorney promptly to understand whether you actually have a viable claim and what kind of documentation you'd need to support it. And fifth, and honestly, this is the piece of advice I think matters more than any legal technicality we've covered, have the conversation with your family now, while everyone involved is still alive to have it. Ask your parents directly how their accounts are structured. Ask whether their will and their actual account designations actually match each other's intentions. So many of these disputes only happen because nobody asked the uncomfortable question until it was already too late to get an honest answer. Here's my honest take. And I say this because I've seen how these situations quietly poison family relationships for years, sometimes permanently. The money itself usually isn't even the real wound. It's the feeling of being blindsided, of discovering after the fact that decisions were made, sometimes accidentally, sometimes not, that completely altered what you thought you were entitled to. That feeling festers in a way that's so much worse than an honest, slightly awkward conversation ever could be. Every single one of these legal landmines we just walked through, the gift tax surprise, the divorce exposure, the funeral money that legally isn't obligated to pay for the funeral, every one of them traces back to a conversation that never happened while it still could have. So here's what I want you to do this week. If you have aging parents, ask them directly how their bank accounts are actually structured, co-signer or co-owner, and whether that lines up with what they actually want to happen to that money. If you're already in a sibling dispute over exactly this kind of situation, talk to your mother, your brother, whoever's involved, honestly and directly, before you spend money on a lawyer chasing a claim the statute of limitations might already be closing on. And if none of this applies to you yet, consider this your early warning system, because the best time to fix a joint account mistake is years before anyone passes away, not in the painful, complicated aftermath. Because at the end of the day, the goal was never just protecting money. It's protecting the relationships that money so often ends up quietly damaging, simply because nobody had the slightly uncomfortable conversation early enough to prevent it. And if you take away just one thing from this entire video, let it be this. The will is not the whole map of what happens to someone's estate. It's one document among several: account titling, beneficiary designations, joint ownership structures, and any one of those can quietly override what the will says, completely legally, without anyone intending to deceive anyone else. The families who navigate this well aren't the families with the most money. They're the families who took the time, while everyone was still healthy and clear-headed, to make sure every one of those documents actually told the same story. If this video helped you understand a situation in your own family a little more clearly, share it with the relative who needs to see it. And if you want more honest breakdowns of the family and money situations nobody warns you about until you're standing right in the middle of one, make sure you're subscribed, because there's plenty more of this conversation still ahead.